Hi everyone, this is Tamal Muthu. Welcome to my Yahoo Messenger case presentation. In this summary presentation, I'm going to quickly recap the introduction about the case, the details, and the discussion points, and the follow-up. This case is about a Romanian employee, Bogdan, who is a sales engineer working at a private firm in Bucharest, Romania. He got terminated from his employment for using Yahoo Instant Messenger tool to exchange personal messages with his fiancée and brother against the company's policy. This incident has happened in 2007. More information about the case. The Yahoo account handle Bogdan was using belongs to the employer. Bogdan is completely aware of the policy that restricts using company resources for personal purposes. After several appeals in the domestic courts of Romania, the case went to European Court of Human Rights in 2016, almost after 9 years since the date of incident. Bogdan's argument is that his employer's decision to terminate his contract had been based on a breach of his right to respect for his private life and correspondence, and that the domestic courts had failed to protect his right. The European Court of Human Rights gave its verdict that it is not disputed that the applicant's employer's internal regulations strictly prohibited employees from using the company's computers resources for personal purposes, and it is not unreasonable for an employer to want to verify that the employees are completing their professional tasks during working hours. So Bogdan lost the case in 2016 at European Court of Human Rights. So below is the link that I have been provided for the case study. So these are the discussion points that I have posted for your feedback. What would you do if this happened to you, if you are in place of Bogdan, and your opinion on the verdict, and who you think is right, whether the employer or the employee, and what do you think about the personal privacy in workplace, and what are the issues with the policy implementation that we observe based on this case, and also the implications on workplaces that allows bring your own device policy. Feedback summary. So because of the policies, the employer stands legally right, even though there was an intrusion of privacy into the employee's private life. The policy has been implemented and enforced, but the employee is not completely aware of the depth of monitoring in place for the enforcement. What would you have done to get off the company network for any personal communication? After the verdict in 2016 at European Courts of Human Rights, Bogdan appealed to the Grand Chamber of European Court for Human Rights. It is the highest court and there can be no further appeal. By an 11-6 majority, judges in the Grand Chamber sided with Bogdan. The verdict says an employer cannot reduce private social life in the workplace to zero. Respect for private life and for the privacy of correspondence continues to exist, even if this may be restricted insofar as necessary. Court declined to award Bogdan any compensation, saying that the ruling was sufficient just satisfaction. More details on the verdict. Notification should be clear about the nature of the monitoring and be given in advance to the employees. The extent of the monitoring by the employer and the degree of intrusion into the employee's privacy, noting that a distinction should be made between monitoring of the flow of communications and of their content, that is, the metadata versus the full content. There should be legitimate reasons to justify monitoring the communications and accessing their actual content. Noting the latter is a distinctly more invasive method, it requires weightier justification. Whether it would have been possible to establish a monitoring system based on less intrusive methods and measures than directly accessing the content of the communications. The consequences of the monitoring for the employee concerned and the use made by the employer of the results of the monitoring operation. whether the employee has been provided with adequate safeguards, especially when the employer's monitoring operations are of an intrusive nature. Such safeguards should in particular ensure that the employer cannot access the actual content of the communications concerned unless the employee has been notified in advance of that eventuality. So this verdict is very important and key because there are a lot of companies they were using several security technologies to enforce such policies where it actually exposes the content, the full content of the communication that the employee were using. Personal privacy in workplace. So the Article 8 of European Court of Human Rights says the right to respect for one's private and family life, his home and his correspondence, subject to certain restrictions that are in accordance with law and necessary in a democratic society. So in general, there is a lack of awareness about workplace usage policies among employees, and there is a lack of understanding the intrusive security technologies in place for monitoring. For better privacy, it's always better to stay off the workplace network. There is always a challenge with privacy when companies allow the employees to bring their own device. The employee should always consider the company's network is an asset of the organization. The devices on employer's network will be under surveillance, and also should beware of data being transmitted using the workplace network is still being monitored with the security technologies in place. The data at rest that resides on your device is still protected, but the data in motion that's being transmitted or communicated using your device when they are in the organization's network is still being monitored. So Bogdan's employer didn't suffer any legal implications directly because of this case. The only reason that saved them is their policy. So the importance of policy is key in enforcing such regulations at workplace. The policy should be specific and clear about what being monitored and ensure employee is thoroughly informed about the policies and the extent of monitoring and consequences before giving consent. Policy protects employers in case of such legal battles. In conclusion, having an effective policy is key for employers who want to enforce such workplace usage policy. The workplace policy document should be considered as a critical document by the employees before giving consent. And also the employees should be informed by the employers about the extent of monitoring in workplace and how much data is exposed because of such monitoring. If you seek complete privacy at workplace, it's always better to use your own device and network. And it is hard for employers to not to monitor communications in today's business model. The employees should understand that and take care of their personal communications accordingly. So these are the references that I have used to study the case further and what happened after the verdict in 2016. And I would like to thank you everyone for listening to this presentation and participating in the discussion.